done the legal frameworks, governance issues about how the world operates, in which engineering solutions or potential solutions might one day be considered, have to be not just from a technological through a technological lens, but clearly the lens of wider society. And one of those is indeed law. So Dan, we look forward very much to your exposition and helping guide us navigate through this quagmire, as an engineer might think of it, of international law in the context, clearly, of tackling climate change. Over to you, Dan.
Well, thanks very much. And I wanted to start by thanking the Lauterbach Center for hosting this, Marcus for arranging it here at the Lauterbach Center, and Sean for that very nice introduction. So I actually wrote an article back in 1995 called May We Engineer the Climate. So I've been interested in this for quite some time. I actually also am using the different title here, Is There a There There? It's from the Gertrude Stein quote about Los Angeles, where there's no center to Los Angeles. And so the question was, is there anything related? And so since I think there's not a lot of understanding about how international law applies to climate interventions, I like that title as well. Okay, so just to preview a little bit what I'm going to be talking about today, since I think it's a mixed audience, maybe some with a background in international law, some with a background in climate interventions. I'm going to talk a little bit of some basics. So I'll start with what are climate interventions, just very briefly describing them for those who aren't familiar with it. Then talk about the role and limits of international law. Then discuss what does existing international law say, if anything, about climate interventions. And then finally, what more could and should international say on the subject. So things like, should there be a moratorium on deployment of climate intervention techniques? What kinds of international decision-making should there be about deployment? Other aspects of government norms about transparency, assessment, consultation, and so forth. So that's a preview of what we're discussing today. So just to begin with, climate interventions, it's a very broad term. It refers to quite a few different types of technologies. And this is just showing some of the spectrum, a variety of different technologies. And generally speaking, people divide climate interventions into two general types. One type is to remove carbon dioxide or other greenhouse gases from the atmosphere, and there are various ways of doing this. Very basic way is growing more trees, but then things like trying to fertilize the ocean so the ocean takes up more carbon dioxide, trying to take up carbon dioxide in minerals, and so forth. So that's one general type of climate intervention. And then the other one is what's usually referred to as solar radiation management. And this is discussing or is about trying to reflect sunlight away from the Earth so that there's less incoming sunlight to warm the Earth and thereby cool the Earth. And again, there are a variety of ways of trying to do this. The one that's received by far the most attention is sulfur aerosol management. Aerosols are little particles that reflect or scatter sunlight. And if you increase the amount of aerosols in the stratosphere, then that would be reflecting sunlight away from the Earth and thereby cooling it. We know that stratospheric aerosol injection in general works because volcanoes emit large amounts of aerosol into the atmosphere, and we've been able to measure the reduction in temperature resulting from large volcanic eruptions, like in the Pinatubo eruption in the early 1990s. So we have the essential proof of concept that if you put a lot of aerosols in the stratosphere, they will reflect sunlight away from the Earth and cool the Earth by a measurable amount. In the case of the Mount Pinatubo eruption, it was about a 0.5 degree centigrade for several years. And then, so these, in the bottom left, there's a picture of a plane that would be scattering aerosols behind it, and some of those would then reflect sunlight back away from the Earth. In terms of thinking about these, they're very varied in all sorts of different aspects. And so in terms of trying to evaluate them, there are a number of evaluative criteria that have been proposed, including their safety, of course, their cost, how effective are they in cooling the planet? Are we technologically ready, or is it timely? Would they be able to be deployed relatively soon? And then are they scalable? Some might be effective at small scales, but can we scale them up to the level that we would need to make a meaningful difference on climate change? Now, views on climate interventions vary widely, and this is showing the spectrum. So at one end of the spectrum, I think there's a significant number of people who think that climate interventions pose unacceptable risks. Many would regard them as immoral, and they support a ban on deployment and then possibly research, because if you should never be using climate interventions, what would be the point of trying to do research on them? At the other end of the spectrum, there are a few people, at least now, who think that we know enough about climate interventions to begin to start deploying climate interventions now at a small scale, maybe then ramp up depending on what see the effects of that would be. And then in the middle, there are people who think that climate intervention might be an acceptable policy if research shows that they're safe and effective, and then possibly if we develop some kinds of effective international governance with them. And just my own view, just to put my cards on the table up front, my view is that climate change is a huge problem. On the right, showing some of the effects of climate change, flooding, droughts, melting of the Arctic. So I'm extremely concerned about climate change. I've been involved in the UN climate change negotiations now for 30 years, since they began, more than 30 years actually. And there's been some progress, I would say, but not nearly enough progress. And my confidence level that it's successful in addressing climate change by reducing emissions, which should be the primary focus, my confidence that that will actually be successful in preventing dangerous climate change is relatively low. So I think we really need to be doing research urgently to try to explore all of the different options for trying to address climate change. And if you compare, I think, the risks of doing research versus the risks of not doing research, I think the risks of not doing research greatly outweigh the risks of doing research. And I'll be explaining a little bit more why. But if we don't do research, we won't know about climate interventions. We won't know which ones, what the safety of them is, how effective they are. That then ranges the danger that people will be using climate interventions in ways they don't really understand what will happen. So the dangers of not doing, and then of course the other danger is that if climate interventions prove to be safe, we're going to be taking off the table one of the main ways we could try to address climate change. So we're taking off the table a potential way of addressing climate change, but we're also putting ourselves in a position, if we don't do research, of states possibly a desperation using climate interventions in ways that they don't understand what the effects would be. So I think the risks of not doing research are very significant. I think the risks of doing research are quite low. So I'm very much in favor of much greater effort to try to understand climate interventions. I do think large-scale deployment is premature. We don't know enough now. That's why we need to do more research. We need better technical and scientific understanding. And I think we need a much more informed discussion internationally about the issue, because there's been relatively little discussion by policymakers of climate interventions. It's been something of a taboo topic. It's not very well understood. The discussions, as I understand them, at the international levels in bodies like the UN Environment Assembly have not been terribly well informed. So I think there's a great need for more understanding of the issue and the beginnings of discussions among policymakers on the issue. So that's sort of where I am on this issue, just in general terms. Okay, so let me turn now to international law and what international law says about climate intervention and what role it could or might not be able to play. So for those of you who have an international law background, basically I want to distinguish between three types or sources of international law. So treaty law, of course, is I think central in the climate change regime. Treaties like the UN Framework Convention on Climate Change, the Paris Agreement. Treaties, though, bind only those states that consent, and I think that's the essential thing to know about treaties, is treaties do not bind non-consenting states. States have to ratify treaties and become a party to the treaty in order to become bound by the treaty. Now, in addition to treaty law, there's also what I call non-treaty law, which encompasses both customary international law and general principles. Quite uncertain what exactly the rules of customary international law or general principles are. Lots of debate about that. With a treaty, you can go to the treaty text. There's an actually written document. You can go, now there might be questions of interpretation of exactly what the treaty means, but at least you have a text to anchor your discussion as to what the rules are. what the rules of customary international law are, what the general principles of international law are. They're not written down anywhere. People have very little different views about them. Institutions like the International Court of Justice opine on what the rules are, but there's no definitive way in most cases of actually determining what the rules of non-treaty law are. So there's a lot of them that goes involved later. And then finally, in addition to these legally binding forms of international law, many people would also include soft law as an important part of, if you think about law more broadly. Soft law is not legally binding on the states. Soft law includes things like codes of conduct, guidelines. These can be developed by states. They can be developed by non-state actors. In most cases, decisions of parties and conferences of the parties, the COP decisions, the decisions of the Convention on Biological Diversity, COP, these are not legally binding. The treaties do not give the COPs in general the power to make legally binding decisions. So they're in a sense a form of soft law. Okay, so I think it's important to try to understand the both the role and the limits of international law, because I think international law is often both under and overestimated in terms of what it can do. People either veer from saying it's completely useless to thinking that international law can solve. So I want to try to sort of draw some boundaries about a maybe more realistic way of thinking about the role that international law could play here. So I think there's significant limits of international law. It depends primarily on state consent, as I mentioned. So if the state doesn't consent to a treaty, it's not bound by the treaty norms. There's no centralized legislature to say what the rules are. It depends on these processes of negotiation, which are very difficult, as we've seen in the climate change context. There's extremely little enforcement capabilities. There's nobody to, there's the Security Council in theory can enforce rules of international law that we've seen, for example, in the current conflict in Iran. There's quite limited ability to actually enforce international rules. Countries can impose economic sanctions, but whether those will actually be effective in getting a country to change its behavior, uncertain. And then finally, as a result of the limited enforcement mechanisms, compliance relies heavily on voluntary implementation. It relies on states basically being willing to agree, or do implement what they say they're going to do. So what are the implications of this for climate interventions? So I think it's going to be unlikely to be able to secure broad international agreement on ways of governing climate interventions. I think powerful states in particular are going to be very likely to resist legal constraints, so that even if some countries are willing to agree to some kind of international process for dealing with climate interventions, whether the states that we really care about agree are going to be willing to join, I think is highly questionable. And then finally, even if they agree and join, if they don't comply, if they behave in a rogue manner, either out of desperation or because they had no intention of complying in the first place, there's very little that we can do to try to stop that. So there's the potential for rogue deployment. So that means that if a country, even if you have a ban on research, a ban on deployment, it's likely to be binding those states that are acting in good faith. And the ones that you're most concerned about are the ones most likely to not pay attention to whatever you do. Okay, so that's the limits of international law. But that may lead you to think that international law has nothing to do in this case. It's completely useless. And I wanted to start with the limits to sort of counteract some of the magical thinking that I think sometimes takes place with respect to international law. But I think it's also important not to go to the other extreme, because international law in some cases has been quite effective in facilitating cooperation among states. If states want to address an issue, international law is an important means for them to try to coordinate their behavior, establish norms, prevent friction and control. And just a few examples of significant successes in international law. The Montreal Protocol is the most prominent one. That's the agreement that deals with depletion of the stratospheric ozone layer. Been very successful in reductions in production and consumption of ozone-depleting substances, and the ozone layer is now on the road to recovery as a result of the Montreal Protocol. So that's been a highly successful agreement. One that's maybe less well known, Somali piracy. There was a coalition of states put together quite quickly to try to patrol the coastal areas of East Africa to try to combat Somali piracy. And again, that involved quite a few different states that agreed to basically work together to try to deal with this common problem. Another is the space station agreement. So the space station agreement is the basis for building the space station, for regulating the space station. Even in the current times when the US and Russia don't get along at all on anything, they still are cooperating under the space station agreement. So this is an agreement that has actually been durable through very, very difficult geopolitical and was negotiated to deal with very many issues that arise with respect to how the space station operates. So these are just three examples of international mechanisms that have been developed to try to deal with issues of common concern. So if states want to have a desire to try to address geoengineering, climate interventions, then international law can be an important way for them to try to coordinate their behavior, prevent frictions, facilitate action. On climate interventions, I think some of the roles that international law could play, I don't think it can play a role in preventing rogue actors from going ahead, but it can play a role in establishing institutions that help coordinate. For example, the World Climate Research Program Lighthouse activity is an example of this in the climate intervention space. It could help coordinate joint financing. It could establish general expectations about appropriate conduct. It's not going to prevent rogue actors from behaving in a rogue fashion, but at least will, I think, affect actors who are more cooperatively inclined. Okay, so these are just in very general terms, some of the roles that international law might be able to play. Now, I think it's sometimes said that international law doesn't really say anything currently about climate interventions. And I think this is a mistake because international law does establish various general rules that apply to everything, including climate intervention. So it's not that climate interventions currently is an unregulated activity. It is subject to regulation, but of its quite general character. So international law, I think, establishes general norms about assessment, notification, consultation. It doesn't address the broader ethical and policy concerns about research. It's self-applied by states, as I said, there's no centralized enforcement. And there is an existing institution that could potentially play a role. It hasn't so far. And that's the UN Security Council, which is an existing institution, which does have binding decision-making authority, and is in theory, at least, established to prevent conflicts between states. And they could then play a role in addressing issues arising related to climate interventions. All right, let me drill down a little bit more on the specifics of what international law provides with respect to climate engineering, climate interventions. So in terms of treaties, there are many treaties that are potentially relevant to climate interventions, but there are really none that are directly on point. So treaties establish, there's sort of a constellation of treaties that deals with sort of related issues, but none is directly on point. So the UN Framework Convention on Climate Change does not address solar climate interventions. It establishes a general goal of stabilizing concentrations of greenhouse gas in the atmosphere at levels that would prevent dangerous climate change. So the goal is to prevent dangerous climate change to the extent greenhouse gas removal prevents concentrations from increasing in a dangerous fashion. It would be furthering the objective of the convention. Nothing specifically on solar radiation. The Paris Agreement at least has something relevant for solar radiation management because it states the goal not in terms of stabilizing concentrations of greenhouse gases, but in terms of a limit on temperature increase of well below 2 degrees, with trying to pursue efforts to reach the limit temperature increase to 1.5 degrees. And so, while it doesn't say exactly how this could or cannot be achieved, to the extent you could limit temperature increase to well below 2 degrees or 1.5 degrees by reflecting sunlight away from the Earth, that would actually be in furtherance of the goal established by the Paris Agreement. The Montreal Protocol does address dangers to the stratospheric ozone layer. Sulfur aerosol injection, stratospheric aerosol injection potentially could affect the stratospheric ozone layer, and to the extent it does, it would fall within the regulatory competence of the Montreal Protocol. Montreal Protocol, though, the regulatory approach is to limit consumption and production of specific gases. So sulfur aerosol, stratospheric aerosol injection would only be directly regulated by the Montreal Protocol if they added one of the substances to the list of controlled substances under that agreement. So it would apply in general to the problem, but there's no specific regulatory measures under Montreal that would apply currently to stratospheric aerosol injection. UN Convention on the Law of the Sea, or UNCLOS, establishes some general principles, nothing specific. The Environmental Modification Treaty, ENMOD, deals with environmental modifications for hostile purposes. So if climate interventions were used in a hostile way, not to prevent climate change, but to actually try to harm another state, that would be addressed by the Environmental Modification Treaty, it would be prohibited by that. But using climate interventions to try to simply limit temperature increase to try to prevent dangerous climate change, that would be outside the jurisdiction of the UNMOD Convention. The London Convention and Protocol deal with disposal of materials from land and sea. So this has been applied to dumping of wastes that are generated on land and sea. It has now actually been, by decisions of the parties, extended to include ocean iron fertilization. So placing iron in the ocean to try to fertilize the ocean so that the ocean takes up more carbon dioxide. That now is under the jurisdiction of the London Convention Protocol. It's extremely difficult, extremely complicated what the exact legal situation is, but at the moment, there's no binding prohibition on ocean iron fertilization because there's an amendment to the protocol, the London Protocol, that is not yet enforced, so it does not actually apply legally to limit ocean iron fertilization, but it is very much to be discussed under the London Convention and Protocol. And then there are various regional conventions, the Long Range Transboundary Air Pollution Convention, which deals with transboundary movements of sulfur. So to the extent sulfur was used in stratospheric aerosol injection and had transboundary effects, could come within the competence of the LRTAP Convention. That applies only on a regional basis, so it doesn't apply globally. The ESPO Convention deals with environmental impact assessment. The Aarhus Convention deals with public participation and decision-making. Again, these are regional agreements, so they don't apply to solar geoengineering activities generally, climate interventions generally. If China were to engage in climate interventions, for example, or India were to do so, then neither of these conventions would be applicable dealing with environmental assessment or public participation. So there's a whole variety of treaties. I'll just give a very quick overview of them. Lots of treaties, some of them are relevant here, but none of them are really directly, none of them have specific regulatory measures addressing climate interventions. I think what's more relevant are the general evaluative standards that are established by customary international law, because these apply to all activities, including climate intervention activities. So I highlighted here in bold 3 of them that I think are particularly relevant. One is the duty to prevent significant transboundary pollution. So states have an obligation under customary law to use due diligence to prevent significant transboundary pollution. To the extent that climate interventions have significant transboundary pollution, then states would have a duty of due diligence to try to prevent that pollution, that transboundary harm from occurring. Now, that duty to prevent includes the duty to regulate private actors. So I think a big question in climate intervention governance has been the potential for private actors actually to engage in climate interventions. I just finished reading a novel called Veil, which is about solar radiation management, and a private entrepreneur basically is deploying large numbers of planes in the stratosphere and is holding temperature increase basically constant, so a temperature constant. So it's not, and so the premise of that is that he's doing it secretly without being detected. States would have a duty to, under the duty to prevent, the duty to regulate activities by the private actors and use due diligence to prevent them from doing things that cause significant transboundary impact. So to the extent that, for example, solar radiation management causes the monsoon to shut down in India, causing massive transboundary harms to India, states would have a duty to use due diligence to prevent. And that includes regulating private actors. And I think one of the big gaps that's not sufficiently discussed in climate intervention governance is the lack of national regulation of private actors in many cases. So when a private actor engages in things like putting things in the stratosphere, or putting iron in the ocean to try to take out carbon, it's unclear in most cases whether there's any national law that actually regulates that. And under the duty to prevent, states do have a duty to enact legislation or use due diligence to actually regulate and control the activities of their corporations, private actors, billionaires or trillionaires who might be doing things that affect other states. Okay, so that's the duty to prevent. And then I think under the duty to prevent, there's now increasing agreement that the duty to prevent or use due diligence to prevent transboundary pollution includes the duty to assess, that you have to assess your activities. Being diligent in preventing pollution requires you to do advanced assessments as to the potential effects of activities, so duty to assess. And then if the assessment shows that there's a likelihood of causing significant transboundary harm, duty to notify affected states and to consult with other states. So I think under existing international environmental principles, states do have a duty to be trying to use to regulate private activities and their own activities to prevent significant transboundary harm. And that includes duties to assess what they're doing, have private actors assess what they're doing, and then notify and consult with other states. All right, and then finally, there's a variety of soft law decisions, the most prominent of which is the decision by the Convention on Biological Diversity, which in a very soft way calls on states to not engage in climate intervention activities other than small-scale scientific research. That's often overcharacterized as a binding limit on climate intervention activities, but it's actually just calls on states to consider doing this rather than requiring them to limit activities. And then there's something, the Oxford Guidelines. I hate to mention that here in Cambridge, the Oxford Guidelines, but that was a private initiative to try to set forth some principles that would apply to solar, climate interventions. Okay. And then in addition to all of these different rules, there are a variety of institutions that are also relevant in thinking about potential governance of climate interventions. There's scientific expert organizations like the ICSU, the Meteorological Organization, Research Program, Conference of Parties and multilateral agreements like the UN Framework Convention, the Convention on Biological Diversity, Montreal Protocol. Montreal Protocol parties have called for assessments of the effects on the stratospheric ozone layer of solar radiation management activities. A Security Council could, as I said, potentially get involved. Judicial bodies could potentially opine on the legality of climate intervention activities. So a variety of institutions, it's a patchwork, as I have here on the right. There's lack of a good regulatory fit for any of these, I would say. There's limited regulatory competence, but a number of them could play a role in climate intervention governance. In terms of providing a forum for consultations and collective learning, UN Environment Agency, UN Environment Assembly and UN Framework Convention, Conference of the Parties, potential places for that. A little unclear who would be developing norms, some marks there, but it could include under the climate change agreements or under UN Environment Assembly. For technical expertise and assessment, we have the World Climate Research Program, the Montreal Protocol Scientific Assessment Panel, the IPCC. The World Climate Research Program is already playing some role in terms of coordinating research activities. And then in terms of actual regulation and decision-making, I think the only existing institution with actually binding competence is the UN Security Council. That then would require, though, the 5 permanent members of the Security Council all agree with what to do. So that's China, Russia, the US, UK, and France. Now, I think actually you would want all those countries to be agreeing on what to do, so that's not necessarily a problem, but you would need agreement among the 5 permanent members of the Security Council to adopt any kind of decision about what to do about climate interventions, either to lay down general rules or to rule on specific interventions or try to address specific interventions that might be undertaken. Okay, so just the general takeaways here about existing international law. I think it provides a general framework. It only addresses the transboundary physical effects, not the broader political and ethical concerns. And it is, as I say, self-applied by states. At present, there's very limited, I shouldn't have said no there, but limited centralized application dispute settlement or enforcement. Okay, so what should we do going forward in terms of governance? One of the ideas that's gotten a lot of attention recently is the idea that there should be a moratorium on deployment of climate interventions. So a moratorium on deployment. And this would raise a huge number of issues, and I just have up here some of them. Who would develop and adopt it? Would it be done by states? Would it be done through international agreement? Would it be legally binding or just a recommendation? How broadly or narrowly would it apply? How would we define deployment as opposed to research? Would large-scale experiments constitute deployment, and then there'd be a moratorium on those, or would it apply to things not apply to those? Where do we draw the line between research and deployment? How long would it? What would be the terms of the moratorium? Would it be indefinite? Would it have a fixed cutoff date? Would there be some conditions that are specified for lifting it? So my own view, as I said before, is that the most urgent need right now is for research. We need to have research to better understand the risks and benefits of climate interventions, how they might be done most effectively and safely. So in thinking about a moratorium, for me, the question is, would a moratorium promote or deter research? Would it help? Some of the proponents of the moratorium think that it would actually help research, provide a safe space. But I think the question is, in thinking about a moratorium, is that true? Or would it actually act as a deterrent against research or limit research? Now, for various reasons, I actually think a moratorium is a bad idea. And I wrote an article with a colleague, Sue Biniaz, it was published last year, called Why Moratorium on Deployment Should Get a Chilling Reception. And we had a variety of reasons that I want to just go through quickly. So I think one is that reaching people is distracting. It's unlikely to prevent deployment by the responsible actors, so it's unlikely to be effective. I think it could end up killing research rather than promoting research, and I think it would be very difficult. So let me just go through these 4 reasons. So one is, I think it'd be difficult, if not impossible, to actually reach agreement on a moratorium. I think the proponents have quite different purposes in mind. I think some basically are using a moratorium in the proxy for trying to prohibit another. So their purpose is really to take it off the table. Others, I think, have believe that a moratorium will allow the development of good governance of deployment, so good governance can be goal. And then some actually think it would promote research by creating a safe space or social license. So scientists would be able to be free to do research because people would not be worried about deployment. That would create a safe space for doing this good research. But I think as a result of these quite different functions or goals of a moratorium, different actors, there's going to be very different views on all sorts of design questions like the scope issue, how broadly or narrowly does it apply, what's the boundary between research and deployment, is it legally binding or not, how long does it last, what are the conditions for lifting it, does it include any language that actually encourages research, or is it just about prohibiting or having a moratorium on deployment? So all of these different questions are going to make it extremely difficult, I think, for there to be agreement among the different actors that need to agree on getting this. And so negotiating a moratorium, I think, is unlikely to actually succeed. But in the meantime, it would be time consuming, it would be distracting. I think it would be likely to divert attention away from where I think the main focus should be right now, which is doing more research. And in fact, I think some people are likely to argue that pending adoption of the moratorium on deployment, we shouldn't be doing research at all, that moratorium is a precondition for really doing research. And then if developing a moratorium takes the next 2 decades, then that will be basically putting on research activities for very long periods of time. Okay, so that's one reason. I think the maybe the most important reason is even without a moratorium, I think it's very unlikely to actually be effective in preventing deployment, because I think that the state really is incentivized to deploy for whatever reason. It's going to deploy whether there's a moratorium or not. We have a variety of very clear international prohibitions, like the prohibition of the use of force, which when states are motivated to use force against another country, they just do. So similarly here, if a country is really desperate and thinks it needs to use climate interventions, or thinks it can get a benefit from climate intervention for whatever reason, then they're going to go ahead. So I think many states are unlikely to accept it in the first place, so they wouldn't, the moratorium wouldn't even apply to them. I think, for example, China, the US, maybe other major countries, Russia, unlikely to agree, so it wouldn't even apply to them. But even if they did agree and they really felt motivated to go ahead and do it, it's not going to restrain them. So the moratorium would give the illusion that we've dealt with the problem of deployment, would actually not be in reality able to stop deployment from taking place. Then I think a third objection I have is that it could actually deter research rather than unlock research. So if the idea is you run a moratorium to try to create a safe space for research, and that's the reason to support a moratorium, I don't think it's at all clear that that's the case. I don't think it's, for example, clear that people who oppose research because they think that climate intervention is moral and acceptable for whatever reason, they're not going to be any more supportive of research if there's a moratorium. It's unclear who exactly is now being deterred from doing research who now feel enabled to do research just because a moratorium would take place. One of the main arguments against research is that research would actually deter or inhibit efforts to try to reduce emissions. And having a moratorium on deployment would not deal with that issue, for example. There would still be a concern that doing research would potentially provide a rationale for countries to do less in terms of reducing emissions. I think, in addition, even though moratorium in theory is neutral and simply is deferring the issue of what to do about deployment, I think moratorium for many people carries a negative connotation. It can send a negative signal. I think, for example, that the Convention on Biological Diversity decision that invited states not to engage in deployment but allowed for small-scale research actually is usually cited against geoengineering activities generally. So the fact that it's actually not a prohibition on research and small-scale research, that's sort of lost in the conversation. The takeaway message of the moratorium in the Convention on Biological Diversity is that climate intervention activities are suspect, they're potentially dangerous, there's a negative connotation associated with them. And then the final reason that I think the moratorium is a bad way of going is it would be very difficult to unwind. It's likely to become de facto data. The key question would be what would be the conditions for lifting a moratorium, unless those were very clearly specified and would act automatically. I think the natural effect of the moratorium would be it would just go on and go on and go on because there wouldn't be an agreement to lift it. We see an example of that in the moratorium on commercial whaling, which was adopted back in 1982. It was supposed to just be a temporary measure to allow a better scientific assessment of whale stocks, so this whaling could be safely resumed. And it's now been 45 years since the whaling moratorium was adopted, and it's impossible to lift the moratorium. So the moratorium has become a de facto ban on the commercial whaling, rather than simply a pause in commercial whaling to allow science to be done. Okay, so for the variety of reasons that I think the moratorium is not the right way to go. Now, let me just talk for a few minutes about governance, other kinds of governance of climate interventions. And I think there often calls for governance of climate interventions, but there's not much specificity of what one means by governance. Governance is a very general term. It can mean all sorts of different things. And people, when they talk about governance of geoengineering or climate interventions, might be meaning quite different things. So let me distinguish 6 different types of governance. So one is simply providing a forum for discussion. That in a sense is a form of governance. It's not directing any particular, not setting any particular norms, but inviting for a place for countries or other actors to get together and discuss an issue. Coordination of research is another type of governance. Monitoring and effective informational types of activity is another form of governance. Standard setting, that's getting closer to what probably many people think about as governance. But that's just one particular type of governance. Decision-making or authorization, another type of governance, and then accountability and enforcement, another. So this is, in a sense, escalating kinds of governance, starting from ones that are very much simply providing a forum for discussion to ones at the bottom, providing for actual enforcement of norms. But I would say all of these, in some sense, constitute different types of governance. Now, if we think about what type of governance we want for climate interventions, form, I think, follows function. So the real question to start with is not just governance of climate interventions. The first question is, why do we want governance of climate interventions? What is governance for? What is the function it's trying to serve? And depending upon the concern you have about climate interventions, it's going to lead you in very different directions in terms of what kind of governance arrangements you want. So clearly, if you think climate interventions are immoral or unacceptable, you want to stop them from taking place, the type of governance you'd like is a moratorium or ban. If you think research might be carried out in a risky or irresponsible way, the governance you want is some kind of rules limiting or regulating research to try to ensure that research is done in a more responsible fashion. If you think the concern is insufficient research, given the potential need for climate interventions to address climate change as I do, then the main purpose of governance is not actually to limit climate intervention research, it's to address the barriers to research. Barriers like lack of legitimacy, lack of coordination, lack of funding, and that then leads to quite different directions in terms of what kind of governance institutions you want. You want institutions to develop a research agenda, to promote cooperation among different actors. You want norms about information sharing and transparency, possibly some kind of activities to raise money to enable research to take place. So the takeaway here is that I think the rule of thumb is you should choose the governance tool based on the problem you're trying to solve. And it's not the case that more governance is always better, because governance can be a negative as well as a positive. You need to figure out what is your concern about climate interventions, and then what role can governance play in trying to address those concerns, and then what kind of governance you want to try to effectuate your goals. Okay, so it's often said, I think also, that deployment would require international approval. That's the phrase I often hear, that people say, well, you couldn't go ahead and deploy unless you had international approval. But I think this very much depends on what you mean by required, when you say that it requires international approval. Maybe morally it requires international approval. I think there's a serious argument that can be made that individual countries do not be making decisions that affect the entire world, that before a country engaged in large-scale deployment of solar radiation management, there would need to be some kind of international sanction for that. So it's a moral question, perhaps. Politically, I don't think it's actually the case. I think it's entirely conceivable that a country would, as a political matter, decide to deploy on its own without any kind of international approval. And then legally, which is my area, I think the answer is it's not required currently, because there's no general prohibition on climate intervention activities. To do climate intervention, you need to try to use due diligence to prevent significant harm. If there is the potential for harm, to notify and consult with other countries, but there's no prohibition from going ahead. So when people say it's required, I think they really need a moral sense or ethical sense rather than either as a political reality or as a legal requirement. Should there be some kind of process for international authorization or decision-making? Would it be a good idea to have centralized decision-making to authorize various kinds of activities? To do that, to have centralized decision-making, you would need, first of all, a rule prohibiting, and then saying you can only do it if you got the international authorization. And I think this again raises the same issues I talked about with the moratorium. If you're talking about saying no geoengineering activities or intervention activities without international approval. You have to then define what the scope of that is. And then I think there would be the same question I had about moratorium, but would it actually be effective? So will this be giving a false sense of security without providing a real assurance that funding is going to take place? In my view, actually, it's almost impossible for me to conceive that there can be international agreement that would get general buy-in prohibiting geoengineering absent international authorization. So the demand is to not do geoengineering climate intervention without some kind of international process. I think you're saying, let's not do climate interventions ever. So you just should be realistic about that. So if you think that there shouldn't be climate interventions, of course, that's not a problem. But if you think that you want to leave climate interventions on the table as a potential way of addressing climate change, if we don't reduce emissions enough, and if research shows that climate interventions can be undertaken in a safe and effective manner, then saying that you can't do it without getting some kind of international approval, I think is setting up a condition that's never going to be satisfied, and therefore would make it impossible to actually ever go ahead. If you're acting, the only ones who would go ahead are the bad faith actors who wouldn't pay attention to that limitation. And I don't even think it's necessarily the case that multilateral is better, because getting multilateral agreement might prove, even for worse agreement to do that, might prove very difficult to do. So that then some interventions that might actually make sense would be prevented from taking place. I think what's probably more important, so there's a big concern, let me just say a word about that and try to wrap up quickly. I think there's a significant concern about unilateral action. And I think in this case, unilateral can mean quite different things. So the country, one meaning of unilateral is just doing it secretly, no consultation, just doing things without any regard to the other countries involved. But you can also imagine unilateral action where countries take the final decision, but do so in significant consultation with other countries. And I think it would be in the country's interest to actually do that, because going ahead unilaterally without any consultation is likely to lead to conflict, tension, et cetera, et cetera. It would be better to try to consult with others, try to get buy-in from them before going ahead. So I think it's in this country's interest to actually cooperate in this area. They might not want a prohibition against them acting ultimately on their own, but they will have a significant interest in trying to act in a cooperative way if they're able to. And just one example of this is the US proclamation where we claimed a continental shelf. So there was no rule about claiming your continental shelf off your coastline after the World War II. US now, because of developing technologies, wanted to be able to exploit the mineral resources of the continental shelf. So in the Truman Proclamation, we claimed the US continental shelf was something subject to US jurisdiction and control and appropriation of the resources. Now, we did that unilaterally in some sense, but we did it after significant consultations with other countries. So there was not significant opposition to that by other countries. It might have been impossible to actually get an international agreement at that point. So waiting for the international agreement might have made that possible, but it was done in a way that was trying to get by, and eventually was followed by other countries, and now that rule is generally accepted. So that would be hopefully the way something might take place with respect to climate intervention. Liability compensation, I think, is very unlikely to ever take place. There are very few examples of successful liability and compensation regimes. So this is another requirement that I think would be impossible to fulfill. I think really what's more realistic is trying to build on these more procedural norms, trying to make clear that prior assessments are necessary, that there needs to be notification and consultation with other states. There needs to be transparency about activities. So I think this is the more promising direction to go. These rules already to some degree exist, but trying to get them clearly applicable to climate intervention activities, I think will be a significant step forward. Should this be done through treaties or through something more informal? Treaties are generally seen to be promoting compliance, but I think they're much more difficult to negotiate. They bind only those states that consent, and more difficult to revise. So my proposal would be to try to develop these rules more in a soft law way. It's going to be easier to get buy-in. And so just finally, what functions are most likely to be successful going forward in terms of addressing climate interventions? What type of governance I think are we more likely to be able to realistically achieve? I think a forum for discussion, yes. I think coordination of research, likely there'd be interest in trying to coordinate research. I think monitoring and assessment needs to be much more focused on how we can monitor geoengineering activities and assess them. I think there's at least possibility of moving ahead in that direction. Some kind of standard setting, probably on a soft fashion, more procedural. I have that in yellow as sort of in between. And then I think what's unlikely, decision-making procedures, authorization requirements, or dispute settlement. So just takeaways, existing international law, I think, does provide a meaningful framework. I don't think it can realistically prohibit or centrally authorize interventions. And I think the most promising governance lies in these kinds of procedural ones about assessment, experiencing notification. So thanks very much.
Great, we have time for questions. So Dan, if you keep the microphone. Any questions from the floor? Yourself, please. And if you state your name as well, for those people online might be able to hear who you are and where you're from.
Sure. I'm Ewan White. I'm a PhD in international law in the University of Oxford. I'm just visiting.
University of where?
Oxford. And thank you, Dan. Yeah, I enjoyed this. I have a very brief anecdote and then a question. The brief anecdote is just that on your point about what is governance. I was once in a workshop discussing SRM governance, and one of the scientists, when they were asked what governance meant to them, their answer was, "It's how we persuade people to let us do SRM." So I think there is that issue of executive order speaking. The question I wanted to ask you about was the application of the existing law to SRM, the international level, where one of your conclusions was that it only addresses the physical transboundary effects, as opposed to sort of the moral, ethical issues around moral hazard or mitigation terms, etc. I wondered how sustainable that sort of distinction or boundary is, right? Because we might think that a lot of the sort of ethical issues that people raise can be put into the language of physical effect, right? So you could talk about the issue of mitigation deterrence as a context in which the direct physical impacts of climate change are worsened by movements towards geoengineering that sort of distract attention from them. You could talk about termination shock in terms of very long-term physical effects. And so, there seems to be some sort of wiggle room in that conclusion. I wonder if the contestation on that might open some room for arguments about existing international law to have some sort of influence on the debate about where things go here in a way that's slightly more open.
So, yeah, I think you're right. I mean, you could try to rephrase some of these terms that would then fit within the legal norms I was talking about. For example, you mentioned mitigation deterrence. So I guess if you're using due diligence to prevent climate change, and that involves reducing your emissions, and now you are encouraging an activity that will actually deter people from reducing their emissions. That could also be another argument, I suppose. And you could take the argument about, you could try to rephrase some of the arguments about morality, I suppose, in terms of equity and future generations. I do think it gets kind of mushy, some of these things, and some of the moral objections, I think, really are based on purely on ethics and religion rather than on any ultimate physical effects, regardless of whether they're physical effects, humans acting like God and trying to affect the planet. I'm not sure I can think of how that would fit within the kinds of norms that I've been talking about that you address physical effects. But yes, to the extent you could translate some of these more general concerns into the potential effects on emissions or on future generations or harms in the future, like termination shock, yes, that I think these rules would apply. Right. They don't apply in a very specific way, though. That's the problem.
Question at the back?
Right.
Harry?
I think this gentleman knows before me, but
Oh, yeah, Gwyn Dyer, I'm a journalist. I was quite amused at how you managed to convince me, or would you manage to convince me, but we're not already convinced that law is not the way to go about this. But there was a very interesting phrase that popped up in the middle of this, which was coalition of the willing. And I think that that's a key issue. I mean, one of David Keith's workers, when he was at Harvard, once said to me, or maybe he said it himself. He said, if the Americans and the Chinese want to do it, it will happen. If either the Americans or the Chinese don't want to do it, it won't happen if they feel strongly enough. But if they're both divided internally, then it gets interesting. And that's where the role of a coalition of the willing would come in. So tell me, how big is a coalition of the willing?
So when you're talking about a coalition of the willing, you're talking about countries other than China and the US and how that would affect China and the US. Well, so I think, I'm not sure there's a really a definite answer to that. I think it might depend a lot on which countries are part of the coalition. So, for example, I think if you had some moderate number of highly vulnerable states, states in small island states, countries in Africa that are particularly vulnerable to climate change, and they came out in support of and joined a coalition of the willing in support of some kind of climate intervention activities. That would give it, I think, a certain legitimacy that it currently lacks. It would make it much easier for proponents to win arguments domestically, but also internationally. So I think those countries would be, you wouldn't need maybe so many of them. If it was Saudi Arabia and Kuwait and the oil producing states as your coalition of the willing, then I don't think it would matter how many you had as part of your coalition, it would be effective in building support. So I think it depends on the countries involved, but I think if the states that are most vulnerable, who have the most to lose from climate change, actually started supporting climate interventions as a way to try to protect themselves, I think that would actually be quite powerful politically.
Great. Harrow, and then we'll go to you.
thanks. Harro van Asselt, Cambridge. Thanks, Dan, for a very organized and very convincing overview. I just want to pick up on the last point here about where to pursue, which I understand is soft law governance, right? Like it's something that you're suggesting. I think the first question I have is forum, right? Like, so what would you think is the most appropriate forum, given that we tried and failed at Geneva a few years ago? The second is, how feasible is this, right? Like, so you've been criticizing a moratorium for like basically wasting our resources in negotiating something that is not going to happen. So how likely is it that focusing on assessment transparency, like the procedural governance, is likely to happen, particularly given the fact that this is such a contested issue, right? Like, as you showed in the spectrum of views at the beginning. So if we pursue this as an alternative, how likely is this to happen? And I guess which forum?
Great.
Excellent question. I think my focus actually initially would not be on trying to develop these standards, soft law or hard law. It would be on trying to coordinate research because, as I said at the beginning, I think the most urgent need is for more research. And so the soft law development of norms, I think could possibly, I think it's going to be necessary to do, so it's something that can't be avoided. I think as there's more attention being given to climate interventions, there's going to be an increase in activities, as we've already seen in UNEA, possibly the General Assembly, elsewhere. So I think it's unavoidable. So I guess it's not that I think I would be, that's not where I would be putting my efforts, but to the extent it's happening, then I think trying to do it in a softer law way would be better. Maybe doing it in not an international organization among states. You could start by doing it among some NGOs. There was an attempt many years ago, there's been very little progress since then, to have the Asilomar conference to try to develop some standards that was modeled on the Asilomar conference to develop some standards for biotechnologies, I think. So, but that really hasn't progressed really much either. So I think it's going to be difficult. I'm not, I think it's easier to do than a moratorium, but I think it's not easy either. There's no good forum is the problem right now. And part of the reason there's no good forum is there's not a lot of understanding of it among governments. My understanding, I was not at UNEA either, the times it was brought up, was that countries don't have well-formed positions. They haven't considered it in detail. It might be whoever happens to show up at UNEA who's representing the country gets to decide for the country what their position is. So it hasn't risen to the level where I think there's a serious consideration at the central level of what the policy should be. So I think that, before you start developing norms of any kind, you need a much more intensive effort to try to socialize the idea, try to inform officials, other actors. But I think that's beginning to happen, but I think it's pretty slow.
Great. Hugh, please.
It's Hugh Hunt, Centre for Climate Repair. Just first, Dan, thanks so much for regularly coming to visit us in Cambridge. It's really fantastic.
It's a hardship.
That we take the time to come here. The duty to assess and duty to notify and consult. I thought that sounded really good, but I'm just wondering how level the playing field is and where is the duty to assess when it comes to burning fossil fuels, and whether some of the difficulties we have in trying to come up with a governance for SRM is just how poor the governance is for the production of the carbon emissions that are causing the problem in the first place. So duty to assess on both sides of the coin, I guess.
Yeah. Well, I mean, there in theory is a duty to assess in terms of your fossil fuel emissions, but how well that's actually complied with is open question. But I think I agree with you in general. I think there's often a focus on climate interventions in isolation without putting it in the context of climate change. So it's not the case that people would say, well, we shouldn't be interfering with the climate. Well, we're already interfering with the climate in a huge way. People say, well, climate interventions might have negative consequences. Well, climate change is already having huge negative consequences. People say, well, you can apply the precautionary approach and shouldn't do something unless there's more scientific certainty about the safety. But if you don't do anything with climate intervention, you don't research it, you might be condemning future generations to a world of 3 or 4 degrees Celsius higher temperature. So I think considering, and this is one of the problems I have with the London Convention and Protocol consideration of climate interventions, is they're focusing really entirely on the potential negative consequences of climate interventions for the ocean, without really taking, I understand it, taking into account, well, but of course, climate change is having a huge negative impact on the oceans, and ocean acidification is a huge problem. And so some of these techniques that might have negative consequences you don't really know, like ocean fertilization, are dealing with a problem, trying to address a problem that itself is having huge effects on the ocean. So I think we should never be thinking about this in isolated terms, just in terms of climate interventions. Are they a good idea? Are they a bad idea? How dangerous are they? Et cetera. Well, it always has to be compared to what? Compared to not doing anything, climate interventions, and compared to the climate change we're already experiencing and it's likely to increase. And my starting point was that, yes, it would be fantastic if we could address climate change entirely by reducing emissions, but I just don't think that is likely to happen. It's not happening already. It's unlikely to happen in the future. So putting all of your eggs in the emission reduction basket, I think is itself very dangerous, because you're now not considering other approaches as fallbacks or as alternatives if emission reductions don't prove sufficient. So yes, I completely agree with what you said.
Very clear. I was going to ask, is there a woman who would like to ask a question? And you I'm
You filled that role.
standing up for my agenda. No, actually, Dan, thanks very much. It's lovely to see you again and to see where this worksheet will link. I enjoyed the presentation and it certainly was a good summary of, those discussions that are out there. I'm still curious about how you think international law, international law already provides a meaningful framework. And I thought your assessment actually doesn't necessarily lead directly there. We've got some science and technology payments, like the types that you mentioned in the space station, and maybe even one that we created for ITER, which has its own currency even, for fusion power. So I'm not saying that it's not possible that there would be a framework. I'm just a little confused, and maybe it's because there was a quick jump there that I want to give you a chance to address. And it was we had a moratorium on whaling, and then for 20 years, nobody got to whale. It was supposed to be a moratorium for research. The research showed that whale populations were failing, and it was a really bad idea in a lot of areas. And so some of the moratorium stayed in certain ways. And I'm just wondering if that's a change you're also thinking of in the international law providing a meaningful framework, where there really is in between the moratorium and the do the research an actual interest in doing the research and learning from it and assessing things based on that research. So I'm not disagreeing with your overall point. I'm just want to give you a chance to get there in a different way.
So on the whaling moratorium, it is still in effect. The moratorium on commercial whaling is exactly the same as it was originally. There's some limited exceptions to it that have always existed. And in fact, the scientific committee assessed and said whaling could be safely consumed, not on all whale stocks, but on certain whale stocks. The whaling commission disregarded that. It's a political issue. It's not a scientific issue anymore. I think, lift the moratorium on the fires of 3/4 vote. So that even getting the moratorium requires 3/4 vote, but lifting is required. So it's a one-way to match it, where it's very difficult to lift.
But it's your interest on the research or on getting whaling done? Because I got your presentation that your interest was in the research, not getting the climate repair done yet.
Yes, but I'm sorry, just on the whaling thing, I just wanted to finish and say, the chair of the scientific committee resigned because he said if our advice isn't being followed, what's the point of being on the scientific committee? It's just a political
And
issue.
they were so well done. We can disagree on that.
But anyway,
is it research or is it getting climate repair done?
Well, it's to do research to determine whether or not climate repair can be done in a safe and effective way. So it's not prejudging whether to do the repair. It's to determine whether we should be doing the repair.
Cool.
Yeah.
I've got a question for you, Dan. London Convention, London Protocol.
Yes.
I had heard that there was discussion regarding lumping marine cloud brightening into that. What are your thoughts on that?
So, in my view, marine cloud brightening wouldn't be within the existing mandate of the London Convention Protocol because that's addressing transporting materials from land and disposing of them in the ocean. And so the marine cloud brightening is taking sea salts and then putting them into the atmosphere to create cloud condensation. That's not would fall within the remit of the London Convention Protocol. Now they adopted the provision dealing with iron ocean fertilization by amendment.
Yeah.
Countries can amend the treaty however they want. So if they want to expand the jurisdiction of the London Protocol to include marine cloud brightening or even sulfur radiation management, stratospheric aerosol injection, they could do that. It would change the treaty dramatically because it would no longer be simply the treaty about disposing of materials from land in the ocean. It would now be about climate interventions generally. But if they want to amend the treaty, countries can amend treaties however they choose to. But I would say under the existing treaty, without an amendment, marine cloud brightening would be outside of their jurisdiction.
So can I just,
Yes.
I hadn't heard about it. So is this taking seawater?
Yes, I know.
Putting seawater back into the sea?
Yeah.
But don't ships do that already to cool their engines?
Yeah.
They take seawater, cool their engines and put it back in the sea.
But your child will actually splash around in the sea.
So London Convention does not deal with pollution, pollution from ships itself. It's dealing with material from land disposed of at sea. But it deals with what ships produce themselves. That's dealt with by a different convention, Rockwell Convention. So yes,
Right.
yes.
And then further question from me, Dan. If there were a ban on research for climate interventions, then and countries, certain countries then signed up to this. What's the risk that effectively the activity doesn't get stopped, but basically just gets shifted to other countries where perhaps the same rigors of intellectual curiosity and standards are not adhered to? What are your thoughts on that?
If you're saying if there was a ban
On research, well, certain people have called for a ban on any government funding for climate intervention research in any outdoor experimentation.
Well, so first of all, I think it would be a bad idea.
Okay.
As I've already said. But I think it would certainly limit research in those countries that adopt this as ban. It wouldn't obviously prevent people from engaging research elsewhere. So that unless the ban were universally adopted and adhered to, it would shift it to countries possibly with lower standards or lesser requirements. It's unclear, of course, who would adopt this, but in my view, countries should, what I've written about this is countries should be developing model research programs to try to model good behavior on research. So requirements about assessment, transparency, and so forth, publication of data. And that should be, some countries like UK and the ARDA program should be going ahead and modeling what a research program should look like to try to then influence other countries' research programs. I think if you start banning research, then it's the research will migrate to other countries that may have lesser standards.
Cool. Any other? Yes. Have you named an institution?
My name is Beijing. I'm a PhD student international law from University of Warren, but I'm conducting research visit here in Northwest Center.
Great.
Actually, I have two questions. So the first, mainly around state responsibility. So I'm thinking of potentially the harmful effects of termination of deployment. Let's say there's already deployment and we have the termination. I'm not really sure about the scientific side of the negative harm by termination, but I'm wondering when the state itself is harmed, whether it should compensate and how it should compensate to the others. That's a different scenario for transboundary harm, because for climate interventions, if the state itself is deployed, but it's also because of the diffusive nature of climate, itself is already as a victim or the harm state under the state responsibility. So whether it should compensate the others, because itself is a victim, let's say, affect the state. And second question is, maybe it's too early to answer, but just imagine there's a coalition of states or entities deploying the SRM, and one entity or one state withdraw from the coalition. And does that withdrawing state also responsible for the harm by the secession, let's say by the termination effect, or is the rest of the state or entities still responsible? I feel like there's a huge transition of the mental state responsibility of this kind of compensation.
So state responsibility only comes into play if there's a breach of international obligation. So it would all depend on what the international obligation is. So I'm not sure what the international obligation is that's being breached here. So you'd have to specify that. Is it that there was an absence of due diligence to prevent transboundary harm? Is that so? I can't answer the question about state's responsibility without knowing what the international duty is that has been breached.
Yeah, maybe I can follow up with that. So as you say, that's the main primary rules right now. Let's say international rules, we have due diligence. The due diligence itself is an obligation of whether resolved. And what I'm saying is that I'm not really sure about what is the actual scientific side evidence of the harm by termination of deployment. So that really depends on the science side.
Yeah, so the duty of due diligence is to basically act responsibly, what a reasonable state would do, given the information it has, given the technology it has. So if you're engaged in solar radiation management, and now stopping doing it would cause termination shock, then I would think a country that pulls out and causes termination shock. And the question would be, is that would a reasonable state behaving, reasonably given its capacity and so forth and so on, do that? And so I started doing it, and you pulled out, then that would not be what a reasonable state was. So you would be responsible for the harms that result from that. But the problem with the due diligence standard is it's basically a standard of acting responsibly or what a reasonable state would do. So it all depends in the context as to how you think reasonable state would behave.
Right. I'm gonna because people will need to go. I'm going to draw a close. We do have some drinks afterwards. We do this continue chatting with Dan. Dan, we'd like to thank you so much indeed for a really stimulating seminar. And those of us who are not lawyers, actually